Good morning, Your Honors. May it please the Court. Christopher DeMeo for Richard Lawson. I want to start by bringing the Court up to date. So I understand from Mr. Lawson that he spent 2015 and the latter part of 2014 in 24-hour lockdown at Suffolk County House of Correction, South Bay, barring a few times when he was let out to go to Bridgewater. So I've only been his lawyer since October. I don't know this firsthand. He was in solitary confinement the first time I went to visit him late last year. Relatively recently, in about January of this year, he was transferred to Bridgewater. So I called up the supervising psychiatrist there to see what's going on. My understanding is that plans are afoot to have Mr. Lawson civilly committed as his prison terms come to an end. So that sort of raises the question, if Mr. Lawson is so sick that he is now having steps taken to civilly commit him, why wasn't he at Bridgewater all along? Why was he at South Bay? Why was he in lockdown for all those months and months?
Yeah, but you may be right, but is that before us?
No, but and the answer I would suggest is that the judge, Judge Coyne, erred when he found back in late 2014 that Mr. Lawson was criminally responsible.
And you say, on that score, I'm just trying to get to this inference or presumption of sanity. So the judge didn't mention it, correct?
The judge did not mention it.
And as far as I can tell, but correct me if I'm wrong, it may be it's part of the district court model instructions, because it isn't part, I don't think it's part of our homicide model instructions, but maybe I'm wrong about that. I just couldn't find it when I was looking.
I will defer to the prosecution on that. I know that it's mentioned in the district court instructions, which we put in the appendix.
Yes,
yeah,
right.
I'm not familiar with the homicide. So yeah, so Judge Coyne, he did not specifically talk about the presumption of sanity. So either his finding was either based on the facts of this case, those particular facts of this case, or else on the presumption that sort of generically applies in all cases. We would submit that the facts of this case do not support a finding of criminal responsibility, certainly not beyond a reasonable doubt, which is the standard here. Mr. Lawson has schizoaffective disorder, which is schizophrenia with a mood disorder superimposed on that, so it's a serious illness. He's been to Bridgewater in and out since he was in his late teens. This was, I think, his 9th or 10th visit as of the date of this trial. He's homeless, he's indigent, he's had run-ins with the law in the past. On the particular date here of the assault at issue, that was March 11th, 2014, he had spent a lot of the prior weeks incarcerated, and in particular from February 21st to March 11th, which is an 18-day period, he had not had antipsychotic medicine that he'd been prescribed made available to him.
Was Middlesex his last stop before being out on the street?
Correct. It was before, I think he was at Nashua Street at one point, and then he was at Dedham, where there was no antipsychotic, and then he was at Middlesex, where there was no antipsychotic. Now, he also is on a mood stabilizer, which was apparently offered to him, and he refused that at Dedham, but then that also wasn't made available at Middlesex.
It was not, correct?
It was not.
Yeah.
So the conclusion is that as of March 11th, 2014, he'd been unmedicated for about 18 days. We'd argue that was through no fault of his own. And the only testimony on this issue about when he becomes symptomatic was Dr. Salvador, the expert, who said he became symptomatic after about a week.
After about a week?
After about a week.
Now,
I thought she saw him about 3 weeks after this incident.
She's reading from
She
the
saw him a
records.
couple of times. She saw him, I believe, 3 weeks after, and he still wasn't on his medication. And then
Right,
she saw him again later in July.
But she saw him, the first time she saw him was 3 weeks after March 11th.
I believe that's correct, yeah.
But she's making the, well, in any event, you agree, I think you agree that whatever she may have said, Judge Coyne wasn't required to accept it.
Well, he wasn't required to accept her expert opinion about whether he appreciated the criminality. I don't think there's any He could disbelieve Judge Coyne on that fact, but that doesn't prove, there's no
No,
basis
no,
to
no,
think
I'm not,
otherwise
I'm just, but.
on the
but-
factual issue, yeah.
So what do you say he had to believe?
I say that he had to, he did not have to accept her opinion as to whether he appreciated the criminality of assaulting police officers. Otherwise, he had to take all the other evidence, the circumstances. Mr. Lawson sort of spontaneously started this fight. This was not a planned assault.
Well, wait a minute, that's reading it in the light most favorable to your client, right? I mean, as the
Well, that's-
Commonwealth is basically suggesting you could take those facts and come up with something that suggests that he was quite sane at the time.
I don't know. I'm suggesting that if you exclude, even if you exclude Dr. Salvador's opinion, the rest of the evidence is, it does support my client. There's nothing about this case, when you compare it to the other cases, where there's almost always some evidence of premeditation, of planning. The person was coherent at the police station. Mr. Lawson was, to believe the government, as I understand, there's an argument that this was all malingering. So to believe that, you'd have to think, well, he was unmedicated for 18 days.
By his.
But he was okay, but then he was sort of acting psychotic to feign for, I don't know, to feign for a insanity defense. And then he kept that up for days at Mass General and was given Haldol injections, and this was all a ruse. It is in the light most favorable to the Commonwealth, but even so, I mean, there's nothing in these facts that
What
lead
about
one to think-
facts just predating and surrounding the incident itself, not what was at the police station, not the admission to Mass General, not any of that, but as of the time of the event? The judge wasn't free to look at the facts in the way that the Commonwealth suggests?
Well, the way the Commonwealth has suggested, if I'm understanding their brief correctly, is that I don't think they're disputing that he had been in and out of Bridgewater 9 times or that there had been these diagnoses or anything. I understand they're saying, well, that may be, but he could have.
People can be sane at one moment and not in another.
I think what the Commonwealth is talking about is the fact that he was laughing and doing whatever he was doing with his friends. And then when the police officer stopped and talked to him, said something about warrants, and at least, am I right, that what your client said in part was he was going to take me away to jail. I mean, and torture me. I understand about the and torture me, but it was about taking away to jail, which was in fact the case, right?
Well, that's true. I mean, the police officer said he saw Mr. Lawson talking to some, I guess, other homeless people for about, I think he said they were 20 feet away from him when he first saw them. So he saw them briefly as they walked down the street. Mr. Lawson, he can talk to people. I don't know there's any testimony here that you have to be like hallucinating to meet the criminal responsibility test. So I don't dispute that. I don't think that proves anything. So you would have to believe, as I understand it, that he was asked for some ID by, well, I think first he asked for a light, which seems like a weird thing to say, but that's what the testimony is. So the officer just said no, and then he asked for some ID. I believe the testimony is Mr. Lawson reached for his side, which seems like something you might do if you're just asked for ID. But for whatever reason, the officer found it threatening, and he touched Mr. Lawson, and then he pushed him, and a fight broke out. I guess to get back to Justice Lang's question about you can be more sane or less sane at different times. From that point on, he fought he fought very ferociously for 5 or 6 minutes. He's screaming out for people to help him. This is like a few blocks away over by the Park Street T station. It's rush hour. They're pepper spraying him. So you would have to, that seems to me like somebody who is not in control. Is it possible he was in control just a few minutes earlier? That's what I think I take the government's argument to be.
I mean, you're asking us essentially to, not essentially, you're asking us, I assume, to find that even viewing the evidence in the light most favorable to the Commonwealth, no reasonable fact finder could find beyond a reasonable doubt that he was criminally responsible. That's what you have to do to win.
That's correct.
But you're not saying that the Commonwealth has an obligation to offer its own expert to rebut your expert.
Not in general, not in general, no, but if
Are you
in this.
saying, are you saying that on these facts they did?
On these facts, well, I wonder why there wasn't an expert here. It makes you kind of wonder whether there was an expert who would testify. But yes, if they're on these facts, they needed more. On different facts, maybe if he had been calm and lucid at the police station, they wouldn't. But these facts, I think, are so overwhelmingly against the finding of criminal responsibility that yes, here they were. But I'm not asserting
Saying that the inferences of sanity here are so slim that in the absence of expert evidence, they could not prove beyond a reasonable doubt that he was criminally responsible.
correct, or some other evidence. If there was some other lay witness evidence that they had just seen him 15 minutes before and he was, but
But you're also saying, I take it, that the judge should not be permitted to rely on the inference of sanity in the abstract, right? I mean,
That's correct.
That should be off the table.
that's correct, and this could have been a jury trial. It just happened to be a jury waive trial. I mean, I haven't argued here, I haven't taken issue with the presumption of sanity insofar as telling the fact finder that most people are sane.
You are
We're
or
not
not?
taking issue. I mean,
Not?
well, people, as I say in the brief, everyone knows most people are sane. So as a general statement, doesn't really make a lot of difference, probably. You have to look at the specifics. So I would argue that when you look at the specifics here, they preponderate so greatly against the evidentiary value of that particular statistic that most people are saying that it's very far in our favor.
I mean, I had thought you were saying, maybe I'm wrong, I had thought you were saying that the presumption of sanity is a legal presumption, which is why, unless there's evidence to the contrary, the Commonwealth, I mean, the fact finder can assume it, but once there's evidence to the contrary, that legal presumption explodes, and then you have to rely purely on inferences in order to, but you're telling me something different than that?
I thought that was what you were saying, too, I have to say.
Well, I'm sorry, the last part, you have to rely on inferences. Maybe that is what I'm saying.
Inferences from the evidence.
Inferences from the evidence, right. Well, our position is that, yes, like any other affirmative, this is an affirmative defense, like self-defense or provocation. There's an initial burden on the defendant to come forward. He has a burden of production to put the issue into play, which is what he did here in order to get the jury instruction. At that point, the burden of persuasion is on the government to prove it beyond a reasonable, to prove that it does not apply beyond a reasonable doubt. And they have to, yes, and it's a totality of the evidence and all the inferences you can draw from the evidence.
But and you're not arguing that part of what the government cannot rely on, once you put it into play, is this abstract presumption or inference of sanity?
What
that most
I've
people
argued
have?
here is that particular inference of sanity should not be able to carry the government's burden in every single case. And when I read when I read the court's cases saying in Kita in 1999 and earlier, there's a lot of law saying, well, we judges can never decide criminal responsibility as a matter of law because the jury always has this presumption of sanity, and that's always good enough. So we can't take the issue from the jury. That's what I'm challenging. I'm saying that this presumption of sanity alone ought not to carry the case, the Commonwealth's burden in every single case. Certainly shouldn't have carried it here. I have not.
Excuse me, are you saying that our approach to this is isolated and that other states do this very differently? Could you explain that?
When I looked at the other states, most other states that I was able to find allow the judges, trial judges and appellate judges, some judicial review on the issue of criminal responsibility. It's
also-
rarely used, but it's something they all seem open to, and that applies to both states that put the burden on the defendant to prove it by a preponderance of the evidence, and that applies to states like Massachusetts that keep the burden on the government. All those states, in the cases I found, either have actually ruled on it as a matter of law or have said they're open to it, and we cite a bunch of those in our opening brief. So yes, I think there's one other state, like I think it's Missouri, which has a similar law here that says that the presumption of sanity can always carry the government's burden in any case, and is sufficient to get to the jury.
Mr. DeMeo, does the record reflect when your client's most recent hospitalization occurred before this crime?
No, I don't believe it does.
Does it reflect how much time he had spent in the House of Correction in Dedham and also the Middlesex County House of Correction before this crime?
Well, like, my understanding is he had went to the Middlesex and Dedham was the period February 21st to March 11th, 2014. That wasn't the in total. I believe he had been at another jail, like Nashua Street, even before that. But that, I haven't focused on the earlier time because I think he was getting his medication at the Nashua Street.
So he had been receiving medical attention while he was at all of those houses of correction?
He had not received his medicine when he...
No. He had received medical attention.
I don't know the extent of what kind of attention he got.
Okay.
Okay, thank you.
Morning, may it please the court. John Zanini for the Commonwealth. The record is fairly sparse in terms of what his prior hospitalizations were, what his commitments were, what his sentences were. At sentencing, around pages 84 and 85 of the transcript, there's reference to the fact he's civilly committed in Bridgewater and that this sentence will be concurrent with that sentence. And if you go further outside the record, he's got any number of convictions. Some were guilty pleas. There are cases in which he never raised a criminal responsibility defense. If you wanted to take notice of those, I could gather dockets and submit them. If you want to stick with the record here, there's one important fact
I'm
I
sorry.
would like to point out.
Is it your view that Judge Coyne, that was part of the record, that Judge Coyne could have considered in evaluating the issue of criminal responsibility in this case?
I'm not sure about that, whether you
When
could.
you mean-
I would think through the expert, through cross-examination, if the expert had really done a really thorough vetting of his record. And the Commonwealth might also be able to present testimony, but I'm not sure about this, from other attorneys who had interacted with him and who had not posed this defense.
But on this record, in terms of what was before Judge Coyne, it sounds like where he would have gotten information about prior hospitalizations, et cetera, would have been through Dr. Salvador's testimony?
Yes, only through what Dr. Salvador said.
Okay.
And I want to point out something very important that Dr. Salvador said, although Judge Coyne presumably simply discredited her testimony, but we don't know whether he discredited some, all, or part. He could have credited the part on pages 51 and 72 of the transcript where she testified that the defendant had an antisocial personality disorder, which is not a mental illness, and that his symptoms were consistent with that, and that causes him to have a disregard for the rights of others. So if she only credited that part of the testimony, that would explain his sudden violence or his choice to engage in violent resistance to the police officer.
But didn't she go on to say that's not what happened here? I mean, it was her opinion that it was actually the mental illness that was operating.
She said, so on page 43, she describes approximately 5 different diagnoses that he's had at some time or another. Her diagnosis, I think, was bipolar on this particular date. I'm not 100% sure. And she did opine that he was not able to conform his conduct to the law. She never explained the connection in any way, shape, or form between the mental illness and his inability to conform, in her opinion. It was a bit of an ipsy-dixit. It's because I say so. There was no real explanation of the connection. But she did concede he had antisocial personality disorder in addition with those, which was consistent with his symptoms. In any event, if the finder of fact discredits the doctor's testimony, then the Commonwealth's burden is proved just by the other evidence in the case.
So let's go there. Does that include, in your view, this inference of sanity by itself?
I would say it can. It need not in this case if somehow this inference is an abstract entity that people can just forget about, which I don't see, that we as human beings can sort of not draw the inference.
I mean, insofar, I'm not good at statistics, but let me just try this on you. It seems to me the argument, I get the idea that as a general proposition, it's probably true that a majority of people are, quote, sane. And one might doubt that, but in any event, let's just accept that for argument. But once you put in evidence that somebody is really, has a whole lot of symptoms of mental illness, whether it's bipolar disorder or schizoaffective disorder or schizophrenia, whatever it may be, that idea that most people are sane seems to me, as a matter of logic, goes out the window. I mean, what's the difference between that and saying most people in the world don't have broken legs? But if I put in evidence that somebody's got broken legs, can the fact finder say, well, since most people don't, this guy doesn't? I mean, it just doesn't seem to me to make sense.
Right, and sane is a vague and imprecise term, as is the entire science around mental illness. So we have a sort of a vague and imprecise inference, because it's not a presumption in Massachusetts. So
But it has a lot of power, or it's
Well,
key to
if-
suggest it does.
right, if the judge used it here, which we don't know, and there's no reason not to use it in the typical case. So there's multiple different levels of this. One is the elements of the crime and the defense of lack of criminal responsibility don't necessarily overlap and coincide. So you can prove the sufficiency of the evidence of elements of a crime, such as assault and battery, dangerous weapon, and then there's a separate and distinct issue of mental disease or defect, ability to conform, ability to know right from wrong. So the general inference of sanity seems not to go to the sufficiency of the evidence. It's a question of how do you weigh and assess the other evidence. You also have a situation where these are exceptional cases, exceptional in the sense that the ordinary course of human affairs, we all intend the acts that we actually engage in. And so to say that the person had a state of mind where he did not intend this act is very exceptional. So we have exceptional and special rules for criminal responsibility. And this is in Leyland v. Oregon, which is, it might not be in the brief, it's 343 U.S. at 804, I think in the concurrence by Justice Rehnquist.
All
Mr.
right, let me-
Zanini,
let me-
may
let
I
me-
ask
let me-
you
I'm
whether
sorry.
or not, given the evidence that was presented by the defendant, it was prudent for the Commonwealth not to offer its own expert testimony?
Well, it's fine for several reasons. First of all, on the face of the evidence, this is assault and battery, dangerous weapon. There's nothing that indicated that the defendant, based on the testimony of the officer, there's nothing that indicated he wasn't making knowing, conscious, intentional choices to avoid going to jail. The officer said to him, the officer pulled up in front of him, he's laughing, joking, walking down the street with his friends. He pulls up 20 feet in front. The defendant then begins to look over his shoulders, is the description of his conduct. As he gets to the officer, he says, hey, do you have a light? Which seems to be, okay, where am I going with this guy? Because the defendant's probably aware he's got warrants out. The officer says, no, you have outstanding warrants. Can I see some ID? And then the fight breaks out with the defendant. So he's resisting arrest and actively trying to avoid going to jail. He even says to the doctor, I thought these guys were going to take me to jail. So if you credit that part of his statement, he knows exactly what's going on. He's engaged in intentional conduct to resist
I
arrest.
understand that that's your argument, but you've got expert testimony, and this person has a documented history, apparently, of mental illness. And I just wonder about this reliance on the presumption of sanity, if that's what you did, not you, but whoever the prosecutor was. It suggests to me that, maybe the Commonwealth should have offered something here.
Well, maybe the Commonwealth should have gotten its own expert for this case in BMC Central, which took 84 pages of transcript from start to finish. But this expert did say he has antisocial personality disorder. It causes him to disregard the rights of others, and it's consistent with his symptoms. So even with this expert alone, you still have a conviction of crime if the judge credits that testimony and not the, oh, he couldn't conform his conduct that day due to his mental illness. So this was certainly sufficient evidence, even with this doctor's testimony, that he's guilty of the criminal acts that he committed that day.
If I can go back to what you said earlier, you observed correctly that this is not an element of the crime, but is it your position, put aside this case, where there is overwhelming evidence that the person is not criminally responsible, that an appellate court could find that no reasonable fact finder on that evidence could find that the person was criminally responsible beyond a reasonable doubt, and therefore could find that he must be found not responsible as a matter of law?
No.
So your view is that you can never lose on this, with regard to this, no matter what the facts were here, you could never lose here. As long as the judge found the person guilty, no appellate court could ever say that the evidence was insufficient to permit the judge to find that the person was criminally responsible beyond a reasonable doubt.
Correct, because you flip the insufficiency analysis. So the sufficiency or insufficiency goes to the elements of the crime. The question is then whether or not there's criminal responsibility. Again, that's for the finder of fact, that's for the jury, and or in this case, the judge, but that's got to be reserved for the finder of fact. They're assessing the credibility, in this case, of the doctor, of the evidence of the lack of criminal responsibility. If they don't credit it, then you look at, that's the end of the criminal responsibility analysis per se, and then you just look at the sufficiency of the evidence of the crime itself.
No, but wait a minute. How can that be the end of the Commonwealth has to prove that beyond a reasonable doubt if the defendant has put it in play.
Right, but the way that you prove it, and I understand that, so you can look at whether there's sufficient evidence of the person, either A, and then that gets to three parts. Did the person have a mental disease or defect?
Right.
But if you don't credit the doctor that there's a mental disease or defect, has the Commonwealth proved that there's no mental disease or defect? Well, if you credit that he's walking down the street chatting with his friends one minute, asking for a light for a cigarette,
Well,
then you get back to,
do you think that take my example with the broken leg? If the fact finder says
he had a broken leg.
he doesn't have a broken leg, even though all the medical evidence that he did, is it okay for the court just says can't review that because they found he didn't, because they didn't believe the medical records?
But this is a very, this is still a developing and imprecise science. He's got 5 different diagnoses. One of those diagnoses is consistent, entirely consistent with him having criminal responsibility and being engaged in intentional criminal conduct. So when you have a really imprecise science and you have an imprecise human standard of sanity or insanity, criminal responsibility, lack of criminal responsibility, that's why we leave it for juries. It's very, very different from a broken leg. A broken leg, I expect you can look at an x-ray.
I don't think if you ask neurologists, they would tell you it is a whole lot different, at least with respect to whether or not somebody has a mental illness.
Well,
or
on this
not.
record, it's not there, okay? There's no record here to say that the science is so precise that you either know, and I respect the fact that you could get more precision about neurological organic brain disorders. You can certainly get fairly precise about that. But statistically, and I didn't file a Brandeis brief here, But if you look at the percentage of criminal conduct engaged in by people who have mental illnesses, it's very, very, very low. It's extraordinarily low. Having a mental illness and engaging in criminal conduct, there's no necessary connection there. There's no sufficient connection. Those are very,
And
very different
mental
things.
illness doesn't mean criminally or not criminally responsible.
Yes, again, then we get to the next two parts of the test. Could the person conform their conduct? A guy's walking down the street, chatting with his friends one minute, asking for a cigarette, and then he suddenly is violently resistant with police. Why? Well, on this record, we know what he told the doctor. I thought I was going to go back to jail. And the officer's telling him you have a warrant. So on this record, the Commonwealth's burden is met by the facts of the case. And then you get the other part of the test is, do they know right from wrong? I mean, that part of the test is, we just assume the average ordinary human being can distinguish right from wrong. If we stop distinguishing that, we're ignoring reality. There's a difference between the qualitative behavior of human beings that we all experience every single day that we engage in, and the quantitative analysis of there's 9 out of every 10 cars is blue or green, what's the next car gonna be? I suggest that that's sort of a misleading quantitative simplification. It's almost determinism. Human beings aren't cars. They're not objects. They're not inanimate objects. And in our experience, every single day, our entire society, our criminal justice system, everything we do is founded on the shared experience we have that human beings know the difference between right and wrong, and they can conform their conduct to the law. And the fact that some people have mental disease doesn't change that reality. We can also, I mentioned exceptional cases and exceptional situations. Even in these cases, you don't have to have a rule where once evidence is presented, the presumption ceases to exist, because this is not an element of the crime. It's not part of the criminal sufficiency analysis in that way. You can still have a presumption after contrary
But as
evidence.
you say, there really isn't a presumption here at all.
Correct. In Massachusetts, I believe we have an inference.
Just permissive inference.
Yes, and the inference is based on all of our common experiences every day and on the facts of the crime, behavior
Why is this
before.
any different than, say, in a gun case, the idea that the defendant has a license? So our law is, if the defendant does nothing, it's not part of the case. But if the defendant puts in some evidence, introduces some evidence that there's a license there, it's going to be the Commonwealth's burden to prove beyond a reasonable doubt that he or she was unlicensed, correct?
That's correct, and
So
it's more,
why is this different?
well, because your mental state is not a piece of paper, and it's not proved by a piece of paper.
But my point is, I'm only going to, I get that, but the presumption or the inference that you're not licensed goes out of the equation if there is some evidence that you were. And so I don't know why this is any different, that if there's evidence that you are suffering from a mental disease and evidence that it made you unable to conform your conduct, et cetera, why doesn't the presumption or the inference go out the window?
And I think you have to stick with inference. So we have, juries use inferences to decide every single case, many facts and cases, many states of minds. They're always using inferences, and those inferences are based on their own brain functions, the way our brains work, our common experiences, our experiences with other human beings. You can't remove the inferences about a person's state of mind from the jury's deliberations. Even the defendant concedes in his brief, they're always going to rely on those inferences. You can't. That's the human process. That's why we have juries deliberate. They draw those inferences. You can't stop them from doing that. Unless the court has further questions.
Thank you. And we'll take our morning break.